Good evening, everybody. A little different doing this on a Tuesday night, but it is pretty important, and I think it is something we need to talk about. So let's see and get this all fired up here. That always takes a second. There we go. How's everybody doing tonight? I'm going to give everybody a couple minutes to get in here, just because this was not necessarily planned ahead of time, and also everybody just needs a chance. Let's get game with it. Yeah, we'll work on that. We thank you for being here, AC. Sweet Tooth. Hey, guys. All righty. You know, yeah, you can say that. I'm generally on time. Pretty close. I'm pretty on time for an attorney. We have a tendency of being a little late, but hey, it happens. And also, I just want to say congratulations to Rosh. Congratulations, you are first. That's always important. One of the most critical things in life. AJ Lowe. Hi, I'm new to your channel. Well, thank you for being here. I appreciate it. If you did not know, I'm an attorney. I am out of Cleveland, Ohio. I mainly talk about criminal defense issues, but this one's pretty big. This one doesn't involve that, but we'll discuss why I think it's very important and why I think we should all know what's going on. Dragon's Treasure. Thank me instead. I deserve it. Well, guys, yes, if you do like tea and you are an anime lover as well, you can go to the Dragon's Treasure. The Dragon's Treasure, a haven for anime and tea lovers. And with the promo code CRIMINAL, you can get some nice tea for a nice price. They have all kinds of teas. They have a tea of the month club. They have all kinds of various teas. They do a butterscotch tea. They sell kettles. They sell tea strainers. They sell everything. Free shipping over $100. End of the year, giving away a PlayStation 5. Everything, all kinds of stuff, guys. White teas, green teas, oolong teas, herbal teas, black teas. Those proud black teas, strong independent teas, tea wares, everything, all at thedragonstreasure.com. Hyla says, when you work that close to the government, you're bound to start operating on government time. Yep, code criminal. Do you think, okay, AC, we'll get to that. And no, I don't think ultimately this is going to go where people may hope it goes, but it's what this whole process started, which I think is the bigger issue. Paul, hi Paul. I'm sorry, I thought this was America. We put tea in the harbor. Well, you know what, Paul? I'll meet you downtown and we can throw some tea in the harbor. So, oh, got a couple more minutes. We'll wait and see who all wants to show up. But yes, Paul, we'll work on that. You gotta dress up like an Indian to do that. Job well done says T-Man individually fondles every tea bag he ships. I've heard that too. I've heard that too. I've heard that too. So Corn 1699 says he'll be in Sandusky, Ohio next month. All software devs or related fields should check out the Code Mash conference next month. If you want to learn to code or you like to code, sounds like a good place to go. Did I see the Aaron Dean sentencing? I did not see it, but yeah, I understand it did not go well for him. Which I don't understand why he got 11 years out of that. That's I mean, if I were him, I'd still appeal it because he's gonna do all that time. Uh yeah. So we shall see. Trot golfer saying who's paying for all these lawyers. Um, I have a suspicion. Well, Kari Lake's paying for her attorneys, and people are volunteering. But when you get to that level, people are willing to jump in the fight and help out. So sometimes they're getting paid, sometimes they're governmental lawyers, but sometimes they're a hired gun and they're willing to help, but they're getting paid from the outside parties and groups. So it can be anybody. Sheeple Hunter says, Ermagerd. Yes, Ermagerd. All right, guys, it's been over 5 minutes. I guess we'll get started on it. So, if you guys weren't aware, Kari Lake is a woman running for the governorship of Arizona. There was another woman, Katie Hobbs, who was running for the governorship of Arizona. Obviously, they both wanted it, and since they both wanted it, there was an election. So, we had the election, and based upon what happened in the vote totals, Katie Hobbs has initially won. Now, Kari Lake believes there was a lot of hijinks and stuff that wasn't going right in that election, and she believes that she is the either rightful winner or that there should be a new election held. And she made a lot of allegations regarding what was happening, and she filed a lawsuit. Now, that's not uncommon. Even prior to 2020, it happened all the time. If you guys remember year 2000, that was a symptom of that happened. But it has happened other times. And myself, I have been involved in election cases before. A person wants to file a challenge to a person's candidacy. They may not have lived in the county, or there are questions about X, Y, and Z occurring. Did they have enough signatures on their campaign forms? Did they sign the forms right? Were the forms marked correctly? I've been involved in those, and that's a very low level. But it's still election law and campaign law is there is case law to support it, but a lot of it is what kind of argument can you make? Now, the higher you get, the bigger the stakes, obviously, but it's something I do have a little bit of experience at. Not Robert Barnes or Mark Elias, but got a little experience. So Kari Lake filed her lawsuit. Katie Hobbs, as herself, as a person, and also as a Secretary of State, and other government officials filed motions to dismiss. They had a hearing last week. The court made a ruling, and the court decided, you know what, we're not going to dismiss everything. We're going to hear some of them. Now, Kari Lake made 8 claims, and we'll go through those right now, and we'll talk about what actually is going to be heard. So, what happened then is the judge issued this ruling. And this was issued on the 19th at 6:30 p.m. So, yeah, a little bit late. A little late in the day, but there we go. Now, here we go. Actually, I forgot to hold on here. I forgot to invite somebody I thought might be interested. And then give me 1 second. Need to close the door. All right, guys, here we go. So we have the Superior Court of Arizona in Maricopa County. That is the county we are dealing with. And we have the judge, Honorable Peter Thompson, Kari Lake v. Katie Hobbs et al. That means and other parties. There's a ton that were listed initially, but we're not going to put them down. It's far easier to abbreviate. So this is an under advisement ruling. So after Kari Lake presented her reasons why to continue the case, and it's a Robert Gouveia raid. Oh, cool, thank you. So the judge had to make a ruling. And he said, after considering the filings and the parties, considering all alleged facts, and drawing reasonable inferences therein, in the light most favorable to the non-moving party, the court finds as follows. And now that is traditional. When you make a motion to dismiss, whether it's a motion to dismiss in civil court or in criminal court, the opposing party is given the benefit of the doubt when it comes to factual matters. You consider the evidence in the light most favorable to them, meaning this is presumed to be true or correct. And is there still a reason to dismiss it? And if there is, then the court will dismiss it. So the background here is that Kari Lake initiated this election contest with her filing of the complaint in the special action, naming the defendants Katie Hobbs, personally as the contestee, and also as their official capacity, the Secretary of State. And that is interesting. The Secretary of State is in charge of the elections, and, well, Katie Hobbs was in charge of her own election, which sounds sketchy, but that happens a lot because Secretary of States generally keep running or run for other offices, so they're still overseeing their own elections, even in other states. And then there were the Maricopa County defendants, the Maricopa County recorder, and then guys named Bill Gates, not that Bill Gates, Clint Hittman, Jack Sellers, Thomas Galvin, and Steve Gallardo, and their official capacity as members of the Maricopa County Board of Supervisors. The Maricopa County Director of Elections, and the Maricopa County Board of Supervisors as a whole. On December 5th, Secretary of State Katie Hobbs published the official canvass for the general election, identifying the votes cast being 1,270,744 votes for Kari Lake, and then for Katie Hobbs, 1,287,891 votes. Obviously, that's more than what Kari Lake got, so Katie Hobbs is presumed to be the winner. I'm fired up. Hobbs can get wrecked. Yeah. Robert Gavere, thank you. So we are going to keep moving there. But anyways, thank you. If you guys are here from Robert Gavere, I appreciate it. Moving down, pending before the court are the three motions to dismiss the plaintiff's complaint filed individually by the Maricopa County defendants, Katie Hobbs in her capacity as Secretary of State, and Katie Hobbs in her personal capacity as the contestee. Because remember, Katie Hobbs is Secretary of State saying, look, we did it the right way. But she's also saying, look, as the other guy running for governor, you should throw this out. I won fair and square. The votes are in my favor. Let's get out of here. So she has to address it both ways. Now, she has her own attorney representing her personally, but she has legal staff representing her as the Secretary of State. Now, their interests at this point are aligned, but they won't always be. So that's why you need your own separate counsels, because they may go down different roads. So a motion to dismiss ought to be granted if there is no interpretation of the facts alleged in the verified statement susceptible of proof that entitles a plaintiff to relief. And this is just a common rule of civil procedure, 12b-6. If you guys have heard these before, this is where you file a motion to dismiss saying the plaintiff has failed to state a claim upon which relief can be granted. That is the traditional term. Sure, hey, all these facts sound great, but there's no legal remedy here. You can't get any relief based upon what happened. This is just a further issue, and they discuss more of how you get to that point. The court does explain, though, in an election context, it must apply all reasonable presumptions in favor of the validity of election. Honest mistakes or mere omissions on the part of election officials or irregularities in directory matters, even though gross, if not fraudulent, will not void an election unless they affect the result or at least render it uncertain. Well, it sounds like here it's got to be very severe. And even then, only if it makes the result uncertain, which, kind of given what we heard, it was a little sketchy down there in Arizona. Now, this is the part about election law where I've told you, you have to be very specific at times. You have to structure your verified statement along in conformity with the applicable election statute. And the courts cannot grant relief in an election if it falls outside the statute. Now, that's very common. You have to be very specific when you challenge things in election context. And I mentioned I've represented people before, and we've had to do it a very specific way. And I've also been the person who gets drug into it after they filed a complaint, and I look at it and say, "Uh-oh, this isn't right. We need to file an amended complaint." And sometimes it's too late. So you have to be very careful. And if you ever want to challenge it at your local level, you're challenging school board member, dog catcher, solid waste and water district people, you have to make sure you follow the law and follow the rules in regards to how do you file a challenge, how do you file complaints, because if you don't, they will dismiss you outright and they're not going to help you. So Kari Lake's first count was a violation of freedom of speech. Her claim is that Katie Hobbs and the Board of Commissioners constituted per se First Amendment violations. Okay, well, the court says, sorry, no, we're not going to buy that. Why? Well, not only does a verified statement fail to set forth an unconstitutional infringement on her speech or anyone else's, even if it did, it wouldn't be misconduct under the election statutes in Arizona, which is Arizona Revised Statute, Section 16-672A1. She claims that there were two acts: the Secretary and Recorder's censorship of certain social media posts by reporting on the DHS and the Center for Internet Security Elections Misinformation Reporting Portal. Now, that's important. We know that now because what have we learned since Elon has taken over Twitter? Wow, well, the government's operating with big tech. And what do? Well, they have had backdoor access. For example, we know Facebook has that backdoor access that I believe is still up as of recently. And even then, now we're learning through the Twitter files that Twitter was actively cooperating with the FBI. And the FBI had granted people at Twitter security clearances to help do dirty work. Yeah. Now, that's where, as of right now, though, this is not an infringement on anybody's First Amendment right. And then the second allegation was the recorder's presentation to the CISA on the needs of election officials concerning purported election misinformation. Okay. The problem is, it's unclear what argument they're making by use of the word censorship. And that's an issue. Did they say censorship? Okay, what exactly are you trying to say happened here? The plaintiff argued she need not set forth a First Amendment claim to prevail. I mean, that's a hard argument to make. My First Amendment rights have been violated. How? Well, I don't have to tell you how. You kind of have to do. Because if you don't tell me how your rights have been violated, how can the court make a ruling? But then it goes on to argue the challenge acts are illegal. And once again, this is the issue. On what basis of illegality of these acts could be argued apart from an alleged infringement? The complaint doesn't say. And that is a problem. You can't just say my free speech. You have to say, here's exactly what they did. Why is that censorship? Why is that infringement on my rights? And them as governmental officials, why are they not allowed to do that? If you don't give that issue, that's a problem. And then through the quintessential censorship, prior restraint, makes no appearance in the verified statement. Okay, well, yes, it appears the court's claiming you haven't even used the word prior restraint at all in your complaint. That's not good, especially if you're making a First Amendment allegation. Oh, sorry. Should pull these out real quick in case that person shows up. I can actually hear them. If I'm going too fast, guys, let me know as well. So, given the verified statement frames this as a First Amendment challenge, the court will proceed on that basis. Obviously, governments cannot restrict expression because it's message, ideas, subject matter, or content. Okay, cool. Yeah. And any content-based laws must be presumed unconstitutional, but there are time, place, and manner restrictions. But any analysis is premised on state action. And this is the First Amendment does not restrain private parties from opposing speech or choosing what to publish. That's also interesting when you get to like the Fifth Amendment. When we talked about is big tech protected anymore? So the key deficiency in this claim is, aside from reporting it, and after the report is made, there's no further conceivable state action. So the argument is, the court's pointing out, after it gets reported, Katie Hobbs is Secretary of State, and then the recorder, well, there's nothing else they do. They tell big tech, and that's it. Okay. Twitter takes down posts that offend its terms of service after a report is made, and nobody else is alleged to have control over that authority to compel such a takedown. Now, we've learned that other groups and agencies do have that power, but not Katie Hobbs or Richter. So that's the issue. While there might be other corrupt government scumbags out there, these two guys don't have that kind of authority. So let's see, keep going here. Twitter or any other social media company is a private actor, and plaintiff has alleged no fact taken in light most favorable to her that leads to a reasonable influence of governmental coercion or control by the recorder or secretary. Like I said, it's got to be through them. They haven't shown it. Nor does the First Amendment restrain government from engaging in speech contrary to the views of some of its constituents. Well, that's true. The government can say things that the people don't like, and it may say things that people don't like. The government is able to make speech. And just keep going here. That's really the biggest issue. What has the government done? And it starts to become problematic for Kari Hobbs in this argument here. And they cite the Arizona Constitution. And they claim that it's a broader, more expansive protection of freedom of speech. And they said in any event, they find no support to the proposition that Arizona's constitution somehow restrains the government from articulating a point of view, point to a public or private party. So still, they say, even with our state constitution, there's no help for you there. So it's looking bad for Kari Lake on this one. Moreover, even if the plaintiff successfully pled a First Amendment challenge, which is saying she got those, and it turns out Katie Hobbs could tell Twitter and force Twitter take those tweets down, she can't argue these amendment violations would constitute election misconduct. The statute requires misconduct on the part of election boards or any members thereof in any counties of the state or on the part of any officer making or participating in a canvass for a state election. Well, that is a problem because is taking down a tweet part of the participation in a canvass or state election? And I think the court here is saying, no, that's not. So they also point out, the court says the secretary and recorder are not automatically members of election boards. And that's true. They're not the board of elections. They're not part of that. The Secretary of State oversees the election itself, but it's not the Maricopa County board. She doesn't have a seat there. Neither does the recorder. The recorder is a separate county official. So if they committed misconduct, it had to be done while they were making or participating in a canvass, and they weren't. She claims, and this is something from reading the complaint you would have to see, these allegations took place months prior to the canvassing and subsequently cannot be considered misconduct under the statute. So yes, there were tweets, there were statements on social media, but they were done in the lead up to the election. So that's the biggest problem. Way before it even started, this happened. So, sorry, this one doesn't work. Even viewing the allegations like most favorable to her, which the court's really trying, says, look, I'm trying to give you the benefit of the doubt here, but it's still not working. Count 1 must be dismissed. So we're to count 2, illegal tabulator configurations. Excuse me. The allegation is the ballot on demand printers that malfunction were not certified and have vulnerabilities that render them susceptible to hacking, according to a declaration attached to the statement. So Katie Hobbs has somebody who signed an affidavit saying, hey, look, these machines can be hacked. They're no good. Additionally, she alleges that the printers malfunction because of intentional action. Now, why? Because it wasn't just one, it wasn't just two, it was quite a few printers were not working. And the person who made that statement that was attached said, there's no way all these machines can malfunction at once absent somebody hacking them or somebody intentionally causing them not to work. Because there were multiple reports of people on election day saying, I was not able to vote. The printers weren't working. We couldn't get ballots. And then there were, I think, even on Twitter, there were videos of elections officials saying, look, guys, you can't vote right now. The stuff's not working. We'll work it out. We have a secondary option. Or if you go vote somewhere else, it can be counted. There was a bunch of fishiness. Does that mean it was impropriety? No, but it was really weird. And that's the thing. Is it weird? Yes. So we should look at it. So the court means that there were two things going on here. The use of the printers lacking certification was misconduct by an official, and that someone did something to the printers to cause them to misprint ballots. The former is not enough to sustain a claim. And why? Well, she cites some United States code and then some Arizona revised statute for the proposition devices and tabulators must be certified under the Help America Vote Act, HAVA. And then the plaintiff goes further arguing the BOD printers, because they fall under the definition of voting system under HAVA, must also be certified. Okay, well, they make quite a few arguments here why they should be certified in case law. So the court then looks into the context of those bills and the context of the statutes. And here they point out courts give the words of a statute their commonly accepted meaning unless a special meaning is apparent from the context. So what does that mean? You read a statute, and unless there's a provision that says, hey, look, when we say X, Y, and Z, we mean something very specific. You look at it and read it, and does it say things you can understand? Yes. Okay. Well, the commonly accepted meanings apply. So from the context of the statutes alone, the court agrees with the defendants. The machines and devices are the same in subsection A and subsection B, and that's only machines and devices that record or tabulate votes must be certified in compliance with HAVA to comply with Arizona law. So it's the ones that tabulate and count. They record and tabulate votes, not the ones who print ballots. So the ballot printing machines are not governed the same way. Now, you think they should be, because if you're counting votes, but the ballots are bad, how do you know this is really counting the right vote and it's being done properly? I agree. That seems very bad. Why aren't the printing machines certified as well? You think you'd want them both, that way both ends are protected. I mean, certainly if one end of this is exposed and open, that means it's exploitable. But what do I know? I'm just a schmucky attorney in Ohio. So moving from there to the Arizona statute, the definition of vote tabulating equipment must apply to any apparatus necessary to automatically examine and count votes as designated on ballots and tabulate the results. So even under Arizona's law, counting and tabulating, not printing. So consequently, a ballot printer which neither examines nor counts nor tabulates is not a component that needs to be laboratory certified. So doesn't count. Sorry, you've already lost there. Now they talk about further about the statute even reference laboratory certification. Since the state use of federally accredited laboratories for certification is discretionary, a federal penalty makes no sense. Thus, the lack of any certification of any printer cannot rise to a claim under the election challenge. So the court's saying, sorry, can't help you here. Now, the second part of that the printer failures render the votes illegal, also fails. An illegal vote's one that cast by a voter who is ineligible to vote. Now, this is part I read, and it was very interesting. What the plaintiff is arguing is essentially a fruit of the poisonous tree argument. That contamination in one part of an election process renders as a result illegal. Now, you would think, and once again, we said, look, if the ballots aren't good, how can the count be good? That kind of leads into the other, and that's the fruit of the poisonous tree, which is that it's a evidentiary rule, meaning tainted evidence leads to bad results, and it's problematic. Well, here we have bad ballots. How can they count? The court says, though, however, that's not the framework given in the either election statutes, which again, this court must construe in favor of an election result, or over a century of Arizona case law interpreting these statutes. The plaintiff cannot point to a single case where an illegal vote was a missing vote, and that's a problem. Sometimes you don't have case law that supports you, and you've got to make the best of what you got, but this is big. Okay, well, where's the harm here? And there is no. It's not cognizable. To the extent such a claim is cognizable, it is under Section A5 and it wasn't raised here. Whew. Well, the court's saying even if you wanted to try to make that argument, it would be under this section and you didn't raise it. So therefore, the court can't consider it. Now, that doesn't mean that had she raised it, she would have won. Presumably, the court would have said, this is the proper spot to make the argument. You still fail. Oh, the sex bots are here. That's always a good time. Shows you're really making progress in life as a YouTuber. So, now, before I tell you it's all lost, the court does find that the plaintiff does not state a claim under A4. The court does find a claim under A1. Viewing the complaint in the light most favorable to the non-movement, the plaintiff specifically alleges that a person employed by Maricopa County interfered with the BOD printers in violation of Arizona law, resulting in some number of lost votes for the plaintiff. So there you go, guys. There is, but wait, there's more. The plaintiff is entitled to attempt to prove at trial that 1, the malfeasant person was covered under A1. Okay, so now she's got something she can go for. 2, the printer malfunctions caused by this individual directly resulted in identifiable lost votes for the plaintiff. Okay. And 3, that these votes would have affected the outcome of the election. So she has to show that these votes being screwed with go up to that vote total we talked about at the beginning. So remember, the vote total is quite a bit. If it just turns out that we change this to, instead of 774, it turns into 925. Okay, that's not enough to change the vote. That's not enough to change the race. She has to show that this would have changed the race and that this would have allowed her to surpass this number. So there is a bit of work out there for Kari Lake. It's not easy. Can she do it? Sure. Well, we scrolled a little too far ahead. So one thing that Kari Lake did allege was fraud. The plaintiff has not alleged fraud nor pled it with particularity. Fraud is one of the few things when you file a civil complaint, you must allege with particularity, meaning you have to be very specific and almost kind of like a bill of particulars. If you were a prosecutor, you would plead out certain points and certain information. Fraud ought never to be inferred from slight irregularities unconnected with incriminating circumstances, nor should be held as established by mere suspicions, often having no higher origin than partisan bias and political prejudice. So once again, you can't just say, hey, it seems sketchy. You have to say, here's what happened. Boom, 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 boom. Here's why they're sketchy. Here's why we believe this constitutes fraud. The other allegations you can. So indeed, on pages 6 and 7 of the plaintiff's response to the incident motions and that oral argument, which happened previously, they disclaim the previous theory of fraud. Okay, well, once you disclaim it, you can't bring it back up, and therefore any claim under count 2 alleging fraud is gone. Plaintiff has nonetheless alleged intentional misconduct sufficient to affect the outcome of the election, and thus stated the issues of fact that require going beyond the pleadings. Now that's important, saying, hey, okay, we've got something we can talk about. So the court takes no position to the evidentiary weight it will give the plaintiff's proffered experts at trial, and notes at trial it must indulge all reasonable assumptions in favor of the election when weighing the evidence before it. It's again, the burden of proof is on Kari Lake to show why that presumption should be overcome. However, evidence is not before the court at the motion to dismiss stage pleadings made under the auspices of Rule 11R. Accordingly, the plaintiff must show at trial the BOD printer's malfunctions were intentional and directed to affect the results of the election, and that such actions did actually affect the outcome. Now, that's the court throwing down the gauntlet that they must prove this. They have to prove this. Oh my gosh, you guys are... Well, at least you're having fun in the chat. So, the defendant's motions that are denied as to count 2 as narrowed above. So, their motions to dismiss count 2 are denied, but there's one little thing Kari Lake gets to go forward on. So, the next thing Kari Lake tried to argue was about the invalid signatures on mail-in ballots, which is sketchy, and they've always been sketchy, and there's always been an issue. Now, as typical has been argued in a lot of these election cases, that ballots were curing and all the problems that could match signatures on file, but the defendants argue the claim is subject to latches. Oh, somebody's here. Hey, Kurt.
How's it going? And it's going great. Watch me shake. Watch me nana.
Sorry, I had to put you on there because I can hear myself talk otherwise.
Yes, no worries. It's fine.
How are you?
I'm doing pretty good today. Thank you for asking.
Good. So do you have a chance to look at this yet at all?
No, I haven't seen this really. I've been doing other things today, and was watching a little bit of Legal Mindset stream, and I figured I'd pop on with you.
Oh, yes. So it's interesting. So out of the 6 of 8 claims were denied, but two of them survived. But it's
Yes,
we're going through to figure out which 2 actually made it. Reading through.
it wasn't the one dealing with the improper chain of custody. Wasn't that one of them?
That's one of them, and we'll get to that. So we're only on 3.
Which seemed like the most interesting based on my superficial understanding of the case.
Yeah, no, I agree. I think that one's a very interesting one. But right now we're talking about the mail-in ballots, and
Okay.
the defendants in this one use the old reliable latches as a defense. Now, latches is an equitable defense. It's a common law doctrine that precludes claims that are brought after a reasonable delay where the delay prejudices the other parties. So
Right.
if you had a right under equity to enforce something, you couldn't wait years and years and years. You actually had to do it then, because otherwise it's not fair to everybody. This is a way to argue that there's a statute of limitations before the concept actually existed.
Yeah.
I think it's the easiest way to describe it.
Yeah, that's right.
Yeah, I tried. At least I want to explain it to clients. So this doctrine bars procedural challenges by election contestants after an election has already taken place. But that's the problem. If you try to do it beforehand, Well, it's not ripe yet because the election hasn't happened. And if you try to do it during the election, well, the election isn't over yet. And if you try to challenge it after the election, they say, well, you're too late.
I'm not sure how you
So,
could challenge signatures
yeah.
on ballots before the elections because they don't exist yet.
Oh, I agree. And that's part of the problem. And even during the election, they're currently coming into existence. So how do you
Yeah.
challenge something that's, that's like you're trying to challenge somebody before they're born, while they're being born, and then after they're born, well, that's too late now because you couldn't do anything before it.
Hmm.
Um, so procedures leading up to an election cannot be questioned after the people have voted, but instead the procedures must be challenged before the election is held. But how do you, other than saying, okay, we're going to make sure our mail-in ballot signatures match? How do you
Yeah,
challenge
I'm not
that?
sure.
Which,
Not sure how that works exactly.
yeah, that's why this stuff is ridiculous. Um, and then they go on to further cite other case law here. Um, Considering first plaintiff's delay, plaintiff makes much of a report by Arizona Attorney General Mark Brnovich, issued April 6th, that reported early ballot affidavit signature verification in Arizona, in particular in Maricopa County, where we're dealing with stuff, may be insufficient to guard against abuse. Whatever merits of that position applied to these facts, the plaintiff was on notice in April of procedural defects she now raises in her challenge and offers no explanation for the delay. I guess
Mm.
she should have said, because you weren't going to let me make the claim earlier. I don't know how else you get around. Like, I'm not sure what other argument you can make.
Yeah. The
You know,
latches, ripeness,
yeah,
mootness issues when it comes to these election challenges
yeah,
can get really weird because it seems as a practical matter that there are, although it's not always true, because
mhm.
sometimes some of these challenges could be made before the election.
Some can.
So sometimes it can, and so sometimes that's fair. It's like you're only protesting because you didn't get the result you want when you could have objected this in the abstract. But this isn't
Yeah,
really one of those because unless you're objecting to the mechanism of how you do it, which would
hmm
be known before the election. But if you're just objecting the fact, well, the signatures don't in fact match, I'm not sure how you would do that.
hmm yeah, and that's so. I think this is the court trying to the extent she relies on a ballot review conducted at 2020 signatures. The report plaintiff relies on was presented in June, again months before the instant election. To bring a belated action is not justifiable. I I don't. I think the court was just looking for an excuse.
Yeah.
So
Mm.
So because the plaintiff was on notice at a minimum months before the election as to the nature of the ballot signature process and chose not to challenge it, then her claim is barred by latches, which I think is interesting because there's another argument. Okay, well, there's a problem with this. There's a this. I mean, think about it. If you file suit claiming this could be abused, all Katie Hobbs has to do is say, "Well, it's not being abused." Case dismissed.
Right.
So I don't know. You can't challenge it until there is misfeasance that's taken place. I mean yeah, that's just, I think that's something that it's
The
going to
only way
take
this
for.
kind of makes sense is if you're not challenging the process, but the determination, but the determination is non-challengeable. Like that'd be the only way that makes sense. Like the law basically says this person's determination is final and cannot be challenged.
Yeah,
That's the only way this makes sense.
yeah, no, you're right. I get what you're saying there. Yeah, this is. So count 3 is dismissed. Count 4, the ballot chain of custody. This is an interesting one. So the claims that the violations of the election manual pertain to chain of custody constitute misconduct. Specifically, plaintiff argues that one, the ability of employees of the county's ballot contractor to add ballots of family members, and two, the lack of an inbound receipt of delivery form, both constitute misconduct.
Yeah.
This, in addition to complaints about the handling of ballots in the 2020 election, 2,000 mules. Sorry about that. The allegations concerning 2020 have no bearing on this contest, and the court does not consider them. And that's fair. Okay, that happened 2 years ago. We can't do anything about it.
Yeah.
Even though you're including it, the court's not going to consider it. So the plaintiff
Redressability
alleges,
is a problem.
what's that?
Redressability is a problem.
It is. It is. The plaintiffs allege that ballots of some number were added by Runbeck. I'm assuming Runbeck is the county ballot contractor, to employees to the total in violation of the Arizona revised statutes. Uh, Further, the lack of receipt delivery, which is just acknowledging the tracking of these, were violations of state law that permitted an indeterminate number of votes to be added to the official results, constituting misconduct. The court, drawing inference in the light most favorable to the plaintiff, as it must at this stage, finds a plaintiff has stated a claim of misconduct by a person under control of Maricopa County that affected the canvass. Okay.
Okay.
Yeah, but you're going to have to show that it actually happened. You can't just say, well, it could have happened.
Yeah.
Yes, if, lack of chain of custody, it seems super sketchy. They're going to have to show that this actually happened here, and they're going to need to show, it'll be interesting to see how they argue this. Because it does happen tomorrow. I don't know if you noticed, if you knew that.
I
Tomorrow
did
is
hear
Kari
that. I was
Lake's.
going to try to make some of it.
Yeah, Viva and Barnes, I think, are covering it.
Oh, that'd be cool. Maybe they'll let me pop on their channel. That'd be fun.
Yeah. So the defendants argue that latches applies. Once again, sorry, you can't argue that we screwed with the election until after the election's over. Sorry, it's too late. But you don't know it happened until afterwards.
Yeah.
So, and it's funny, the court does bring this up. However, latches do not apply to contests arising from violations of the election procedures, as opposed to challenges of the procedures themselves, which
That makes sense. So if the court understood the previous challenge to be challenging the procedures rather than the result, then their answer makes sense.
Yes, and thank God they finally did that, because there were so many times in 2020 where it's like everything. Oh no, we're not hearing it.
Yeah, well, if what they were saying earlier about with the election with the signature verification, if the complaint was the process itself is wrong, then latches makes total sense.
It does,
because look, you could have brought this up anytime. It was there, and now you're just bringing it up now because you're sad. And we are sorry about your sadness and all, but no, right? So, but if this is like not saying, oh, we're not upset with we're not upset with the protocol, we're upset with the execution. That makes more sense. So okay, that makes sense. And that makes the previous ruling much more justifiable.
It does. And the delay, to any extent there was reasonable, because yes, you've got to wait to figure this out.
Right.
So the defendants dispute the lack of compliance with chain of custody laws and claim the plaintiffs have misunderstood the forms required.
Okay, maybe.
Yeah.
So it'll be a very short hearing.
Yeah, sure. As presented, whether the county complied with its own manual and applicable statutes is a dispute of fact rather than one of law. So that's, once you're saying, no, it didn't happen. Well, now we're into issues of fact, which mean we have to have a trial. And that's the issue with the motion to dismiss. You're saying
and you as a plaintiff have to put forward the initial burden of showing it didn't happen.
Yes.
Because the state, being the defense, can just sit there and be like, yeah, we totally did it. Because the defense wins by default.
Yes.
Because they're the defense. You got to show some evidence that would show that that's not true. And then we again do a conflicting evidence. So it's like, what are you bringing to bear? Show this. What is your proof?
Yes. And once again,
it would probably be helpful if it wasn't just like a one-off or something, because
I'm betting it's a
in
lot
every
of
election. In every election, perfect. The law does not require perfection, especially like in an election where you have 2.5 million ballots, right? So it's like, oh, I found one. It's like, you have something a little bit more systemic would be helpful.
Yes. But once again, guys, this is the issue. If you're, when you're trying to do a motion to dismiss, you're saying, look, let's agree everything is correct. There's still no claim. This is where the defendants messed up by saying, nuh-uh, that's not true. Well, once you say that's not true, there's claims that are in contention. So that's when we lead to this. So consequently, plaintiff has stated a claim. The motion to dismiss is counter denied. Count 5 and count 6 are equal protection and due process. That, the intentional discrimination and a due process violation under the U.S. and Arizona constitutions. Even if the court assumes that officials allege violations of equal protection and due process in the conduct of an election would constitute misconduct, the allegations of those violations are merely cumulative and are unnecessary to successfully plead an election contest. In an instance of misconduct by either an election board or a person making or participating in a canvass need not result in a harm against a protected class in order to be successful. A bootstrap constitutional argument takes the verified statement beyond the remedies provided by the election contesting statute, which is impermissible. So that's I saw that the bootstrapping thing that the court is not being very the court's not appreciative of the argument here. So I mean I'm curious to see how you take that, Kurt. Are you still there?
Well,
Okay.
I'm just listening.
Oh, okay. Nor is it apparent from the complaint the plaintiff has successfully pled a successful due process or equal protection challenge at all. And that's where, great, you can say my due process and my equal protection, but you have to actually show it. And just showing,
Mhm.
okay, well, things didn't work out properly to my benefit doesn't necessarily make this an equal protection claim.
Yeah.
So, and that's where the government comes down further and says, um, just because the government violates a law um, in bad faith or beyond jurisdiction, do not necessarily equate that. And that's true. The government can do a lot of, well, I don't know if that's really the proper way to look at it, but at least here the courts are saying, look, they may have messed up, but that doesn't count.
Yeah.
So
I
the
can
plaintiff is,
understand. I can understand the idea. It's like we
yeah,
weren't equal protection requires treating everyone equally. If you're not dealing with
mm,
a suspect class,
yeah.
then you're just dealing with rational basis
You're just dealing
and
with government being the government.
government being the government. So I can see the lack of a equal protection argument.
Yes.
She doesn't have a protected class in this context. She
Yes.
doesn't have a property right in it.
No, she doesn't.
Um, so equal protection doesn't really
Yeah.
work. Due process of law doesn't really work either. She's
No.
not,
Right
yeah,
now
because she's
she's
not
getting
being
her due
deprived. What's
process.
she being deprived of? She's not
Yeah.
being deprived of a property interest, a liberty interest. I mean, squishy as
Yeah.
liberty is, but still, oh,
But you're not
I
entitled to, you're entitled
kind
to
of like,
run, but you're not entitled to win.
yeah. So I think the court is probably right on balance, and also constitutional avoidance principles. It's like if I
Yeah.
can decide this question
Yes.
on non-constitutional reasons, then as a court, I'm supposed to.
Oh, I agree.
So
I agree.
that works too.
Yeah. I'm trying to think of like you're not entitled to win. The only, yeah, what have you been deprived of? Nothing. So, and the court just points out that the plaintiff has trouble drawing a through line from purported discrimination to a well pled impact. And once again, that's like earlier, you've got to lay it out to show how this has happened. You can't just say, oh, well, I've been deprived. You have to show why you've been
You know,
deprived and how it affects you.
also one step removed because it wasn't something they did to you. Really, it was something they did to other people's balance.
Yes.
So the injury isn't
Yeah.
really to you.
Yes.
There's a problem there.
Yeah. You don't have the right to those ballots because it's the people who were deprived of their right to vote.
Yeah.
So, in any event, the finding of either violation is not necessary to ultimately succeed an election contest. The addition of the constitutional arguments are necessary. Um, Even if they do exist, they're outside the scope of the election contest. So, counts 5 and 6 must be dismissed. I think and that's a court's way of saying that seems like a bit extra to go on here.
Fair
The
enough.
Dragon's Treasure for $5 saying no real chat, just general appreciation money before I must go. Well, thank you very much. I appreciate it. If you're heading out, have a nice night. Once again, guys, dragonstreasure.com for tea. Promo
Make
code
good tea.
criminal. Yes, very good tea. Very good
They
tea.
had coffee. I'd promote them more, but they don't.
Well, maybe in the future. Count 7, the
No,
secrecy
they'll have to
clause.
promote Jeremy's coffee brand coffee instead, I guess.
Yes. Yes, Coffee Baron coffee. Apparently it's good. Nick seemed to like it. So the secrecy clause. The plaintiff argues the mail-in ballot procedure is unconstitutional under the Arizona Constitution secrecy clause. This is great because it's
How?
so short. Whatever merit this challenge has, it is squarely barred by latches for the same reasons count 3.
Yeah, that makes sense. Because
Yeah.
again, whatever the problem is,
You could have brought
and
this
what
up
is the
before.
problem exactly, right? And it's like, yeah.
Yes. Yes, the current absentee ballot statute was adopted in 1991.
Single latches problem.
Yeah. Now, but I think there's an argument to say not all, well, yeah, I guess technically not all mail-in ballots are absentee ballots, but all absentee ballots are mail-in ballots. So I think that's the way to look at it there. Yes, so Lake could have brought this challenge anytime in the last 30 years. Now, to be fair, they're not saying she should have brought this in 1991, but she had last year she was running for governor, she could have brought this up.
Yeah.
But as soon as she did it, and knowing 2020 happened, she could have jumped in and said, "Hey, look, this is a problem." To do so now is invite confusion and prejudice when absolutely no explanation has been given for the unreasonable delay. Latches conclusively bars this challenge as the election. Okay, yeah, fair enough. Next time, now, if she were to lose this all the way through and go lose, she could, if she wants to run, whenever she decides she's going to run again, she could immediately start challenging it. But for right now, it's too late. So, incorrect certification. As noted in Mrs. Hobbs' motions in her capacity as Secretary of State and as contestee, remember, guys, she is the Secretary of State and also the challenger for the governorship. Plaintiff's count 8 contains new allegations. The count only asserts that the cumulative impact, geez, I am inarticulate today, of counts 1 through 7 invalidate significantly more Hobbs votes than the certified margin of victory for Hobbs. And that the court will have to declare Hobbs' certification of election invalid and declare the plaintiff as elected governor. The court's reading this as a request for specific relief available under the statutes. If any of counts 1 through 7 are sufficiently proven, but it dismisses it as an independent cause of action because it's not a cause of action in and itself, which that makes sense. You're just stating at the end, yes, throw this out, make me the winner.
Yeah.
That yes, that's not a specific count. That is just, well, duh. If we can prove you won, you won. Although I'm not gonna crap on our attorneys too much because this is being done. But this is being done, under the gun,
rush.
and the thing is, guys, you plead everything. You plead everything at first, and then if you have to, you trim it back. Now, you plead everything within reason and with your ethical responsibilities. Now, on the timetable these guys had, you throw everything out there. But for like a civil case, when you're defending it, you throw out all the affirmative defenses. You deny, latches, unclean hands, any number of things that are out there, and then you'll pare things back as you go. But this is merely just a prayer for relief. Really, I think is what the court's trying to argue there. This is just a prayer for relief that was included as a count, which, no shit, Kari, we know you want to win. So count 8 must be dismissed. All right. Count 9, inadequate remedy. In her count 9, Kari Lake asserts that to the extent the special nature of these proceedings precludes bringing concurrent federal claims against Maricopa County's 2022 general election, this court has jurisdiction under Arizona's Uniform Declaratory Judgment Act to declare that the remedies provided by the Arizona revised statutes here are inadequate to protect those federal rights and requirements. That's a interesting claim, stating that has to happen here. First, insofar as the federal claims which the plaintiff refers to are included in her complaint, the special nature of the proceedings does not preclude concurrently bringing those claims against the appropriate parties. So plaintiff's count 9 invocation of the court's jurisdiction to provide declaratory relief is unnecessary and outside the scope of an election challenge.
Fair enough.
Yeah.
Sounds pretty reasonable.
It does. That's...
Although
You
to
know,
be fair, I've read about half the
uh-huh.
election lawsuits that were filed by Trump or
Hmm.
on behalf of Trump
Yeah.
in respect to the 20 whatever it was 2021
Yes.
election
Yeah.
2020 election. I read about half of those lawsuits and I
Hmm.
agreed with them as matters of law.
Yeah.
I thought they were all basically correct, because, well, not for least of reasons that people are asking for a lot, and
Yeah.
exceptional claims demand exceptional proof is not a bad idea. It's like your ask and your
Yeah.
evidence have got to be parallel. It's like if your ask
Exactly.
is, I want to not get this parking ticket versus your ask is I'd like to be governor now.
Yeah.
The court's going to want a little bit more
Yes.
for just pragmatic reasons.
Hmm.
So I thought, I read about half of them, and I thought that basically half of they were all garbage.
Oh. So,
So I'm not based enough.
yeah. So the court says second, in any case, the court may not provide the suggested relief. A court may provide declaratory judgment only over a justiciable controversy between the plaintiff and defendant that is ripe for adjudication. Okay.
Yeah,
Yeah. So that the court can't. The court can only you can only do that if it's ripe for adjudication. Once again, that's ripeness
I
here.
can't declare your rights if I don't know the answer yet.
Yes. The specific question of whether Arizona Revised Statute 16672 is adequate to protect federal rights and requirements was not in controversy between the plaintiff and defendants before the declaratory action was brought. So, no proceeding lies under the Declaratory Judgments Acts to obtain a judgment which is merely advisory or merely answers a moot or abstract question. And yeah, I think that's because the way I understood this and the way I read it, it was like they were asking the court to make that ruling that the law does not provide them with remedy.
Hmm.
Yet, if the court does that, then the rest of this is moot. And then, well, what do you do? I guess go to federal court, but then the federal court's not going to want to touch this.
No, 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 no
So,
chance.
but then you're going to ask the court to shape its own remedy. That's really scary. Letting them make it up. Um, Beyond all this, a request for a court to concoct a new remedy is a straightforward invitation for judicial legislation, which must be denied.
Yeah,
And when they talk about the new remedy, guys, that's where they saying, "Well, judge, you need to just go ahead and make up the rules as you go." And this judge is saying, "I'm not going to engage
I'm
in."
not really going to do that. I'm not supposed to do
Yes,
that. It's a very
yes,
judicially conservative kind of
yes,
thing. It's like no,
yes,
just no.
yes. So he's saying, "I'm not going to engage in judicial activism. We're going to leave this alone." Um, Count 9 must be dismissed because it's unnecessary by its own terms and requests an unavailable remedy. So the court's saying, look, I can't do anything with it and I won't do anything with it. Therefore, it's getting
Go
dismissed.
away. Yeah,
Yep.
I agree with that.
Yes. Uh, they do talk about the justiciable controversy requirements provided by plaintiff's assertion of a legal relationship status or right in which the party is a definite interest and the denial of it by the other party. Um, their relationship between the plaintiff and the defendants existed prior to the bringing of the action and does not arise as claimed here by the defendants defending against a claim right in the midst of litigation. So they already had their relationship prior. So this didn't arise out of the action. Stating basically the court saying, look, you guys already had these issues. It wasn't like something that came up out of nowhere. So count 9 gets bye bye in the car. And then we're to count 10 constitutional rights, which is funny because she alleges that they may have violated the equal protection and due process clauses of the 14th Amendment.
No,
Okay. We already kind of went over this once, but maybe it'll work out again for you. Second time's a charm.
not a
The,
chance.
yeah, well, I agree. The plaintiff states that such violations may be remedied by this court under 42 USC 1983, independently of the Arizona statutes. Well, if it's under 1983, that's in federal court. This court can't do anything about that. So Kari Lake is claiming that the plaintiff is entitled to an order setting aside the election in its entirety and ordering a new election.
That's a dramatic remedy.
Yes, yes. Well, especially if you're trying to argue I was deprived under the color of law, under a federal statute. I mean, you have to go prove that. That is a separate case. And a 1983 case is a years-long process. So are we just not going to have governor? Are we just not going to have a governor for like 4 or 5 years? Uh, so the statement is correct insofar as this court, the Superior Court as Arizona's single unified trial court of general jurisdiction. They may hear such claims under Section 1983. Wait, what?
No,
Yeah.
not even a little bit.
Did I read that wrong? Wait, how are they claiming they can hear a 1983 case?
I don't know.
I didn't read this one. I kind of skipped it because I knew this one wasn't going to matter. But okay. However, when here is the gravamen of her complaint is the improper conduct of an election, her challenge must conform to the provisions of the election statute. Okay, fair enough. They've said that repeatedly, and I've brought this up before. I have represented people when you challenge conduct in an election, even for the dog catcher, you've got to explicitly comply with the rules. Once you get inside that complaint, okay, there might be a little room to play, but overall, there are specific requirements you have to meet, and those have to be pled properly. This court may hear plaintiff civil rights claims in a separate action, but they must be dismissed from this election contest as outside the scope of the election statute. Okay. But still, how is he going to hear a 1983 claim?
I don't know.
Yeah, that's just, I don't know. I mean, yeah, okay. So it's ordered all of plaintiff's counts, except for 2 and 4 are dismissed. It's further ordered that the prior, geez, this thing is not working right. The court's prior order concerning the ballot inspection take place at 8 a.m. So today there was a ballot inspection of a select number of ballots, not all of the ballots, but a select number.
Oh.
So they further then say the court allocates 2 days for trial. This accounts for all the parties in the petition. Therefore, the ruling to motion to dismiss has narrowed it down. Therefore, the original time estimate's more than adequate. Yeah, and it should be. There's only 2 counts, and one of them is extremely narrowly defined, so the court's giving everybody enough time. The compressed time for presentations based on not only the constraints imposed by the election statute and the short time frame before that, but this gives the parties a chance to appeal before January 2nd of 2023. So the court is actually being cognizant of, look, this is going to be really quick because if either side hates this, you guys need to have the right to appeal before January 2nd when the governor becomes the governor, whoever that may be. The time allocated means each side will have 5.5 hours available for opening statement, direct examination, cross-examination of opposing witnesses, redirect examination of witnesses, and a closing argument. So very much like the Johnny Depp trial, you've got a set amount of time, and you're going to eat into it everything you do.
Do like the chess clock approach.
Yes. 30 minutes is deducted from each side's allocated 6 hours to allow for a 15-minute break each morning and afternoon. So already you're starting out with 30 minutes gone. So this will be very interesting what happens. Now, what do I think is going to happen here?
I don't think she's going to have it.
Yes.
I don't think she's going to have it.
No, I don't think she will, but I will say this much. It is very important that we're at this stage, though. Finally, somebody's being allowed to challenge and present a case in court. And we haven't had that happen before. And
Well,
I
it's
think
not
that's
quite correct. I mean,
to the point where I know, but I think a lot of these courts were like, yeah, we're not going to hear it. And I think some of them, there's, to say none of those were viable or worthy of a hearing on the merits. Regardless of where you are politically, I think that's important that this shows there are some times where you can challenge, because
Sure.
otherwise, from now on, it's, like Robert Bard says, if you try too early, sorry, too bad. And if you try afterwards, sorry, it's too late. Well, then you can never challenge, which is not how that's meant to go. You should have the right, if you meet the requirements, to properly challenge an election. Otherwise, that leads to, certainly when the shoe's on the other foot, that leads to whoever doesn't like that now, they're going to like it later.
But the shoe's never on the other foot because all elections are perfectly fair and good and secure in every possible way.
Yes, very secure. Most securest elections in the world, Mama Susan. So yes, I agree. I don't think she's going to win, but I do think it's also important, though, for Maricopa County. We keep hearing about it. This county is clown shoes. They keep screwing up. Things aren't right. Like, how the hell does it take you guys 2 weeks to count? Why can't you get
Good
it done?
question.
And instead of having some dopey legislative session where it could say, like, well, Senator, I will try, or we'll get back to you on that. No, your ass is sitting there in a chair in the witness box under oath, penalty of perjury. Why do you suck at your job? Why can't you guys do this right? What is this? And I think were that to happen in a lot of places, that's how you fix elections. That's how you fix government, is by, not saying, oh, here's a subpoena. It's like, no, bro, you're coming to sit in court and you're going to have to, everybody in the country is going to see you go up there. And I'm sure some of these Maricopa County officials are going to look like complete morons.
That's quite possible.
Yeah. And I mean, I think that's important. So, let's see where we are here. Okay. Well, we got a couple of things here. Catherine K is new member. Yeah, thank you, Catherine. I appreciate your support. Elegant News says for $4.99, didn't Lake have a prior lawsuit with Alan D that got dismissed and legal fees put back on Lake? What was that case about? I don't know. I'm not sure what that's about. But yeah, sometimes that could happen. And I know in this one, people are jumping up and down about saying sanctions for these parties or frivolous claims. I don't think that is a very, that kind of goes back to the idea, she did present some claims. Okay, some may not have been under the right statutes or timely filed. But to start saying, well, unless you nail it on the nose, we're going to hit you with a frivolous sanction, I don't think that's how you want the courts to react to people filing lawsuits in this manner. So
That's true.
I don't think that'll happen. I hope it doesn't happen. Because that, the chilling effect, like that'll be a very chilling effect if you got to risk your ticket for something like this. Especially you with that brand new Texas ticket, by the way.
Thank you. I do like having my brand new ticket.
Yes.
It makes me feel all Western and official and stuff. I need a belt buckle now.
Well, if you go to court, I think you can wear a bolo, can't you, in Texas to court?
I think you can, and I was told once, although I've never bothered to look it up, that you can wear a cowboy hat.
You can.
I'm not sure if that's true or not, but I heard that once.
Well, you can wear your cowboy boots to court too. So
I'm sure you can.
Yeah.
Bolo ties for the win, baby.
Yeah, I mean, you can get up there and you can have like suspenders on. You can like flick them, like, well, I'm just a simple lawyer from Texas, ladies and gentlemen.
Loving it already.
Yes. Jacob Castro saying, how long would it take before we get some Twitter drop or something that confirms it was all done on purpose? 2 years? Maybe. We'll see.
The fact the FBI was apparently giving money to Twitter.
Yes, although the way it was being alleged is that when they requested Twitter to do something, they were compensating them for their work. But yes, Twitter was voluntarily doing it beforehand.
That's a little bit, that's where we're crossing that line.
Yes. Oh, I agree.
Into governmental action.
Oh, I think
because now they're asking you to do something and they're paying you for it.
Yeah.
I'm like, dude, man, that looks a lot like governmental action now.
Oh, it does. And I love the idea, like, oh, well, they're not being compelled. I'm like, I don't think the people who came up with these doctrines ever thought a company was like, compelled, oh my God.
Compelled isn't necessary for governmental
no, it's not, but
agent doctrine.
But there's a lot of I think there's a lot of argument that, oh well, nobody's being forced. I'm like, these guys are voluntarily helping. That
Yeah.
that is that
That
is a
that's
governmental agent.
right.
Yeah,
Yeah,
like
just
we're gonna
because the
help you.
guys help. Yeah, if if the police go up to a guy and be like, "Hey, we can't search this house because we're the police. Would you mind popping your head in there and looking for us?" And the
Yeah.
guy's like, "Okay." Right? I mean, he's not being forced to, but does
Yes.
anyone think that's not governmental action? I mean, give me a break.
Yeah. Well, and even then, I don't know if you saw it, but the FBI was giving Twitter people, I think including some of the trust and safety team, security clearances to go dig through stuff when they were dealing with the Hunter Biden things.
Nice.
So it's like, how much that pretty much makes you a governmental agent when you're being given security clearances. I don't know how much more you need to be, but I also just think I don't think
They were able to pass the security clearance?
some of them were. Yes. Well, hey, oh, I'll leave it at that for now. But yes, um, well, Ilhan Omar can pass a security clearance. Anybody can. Um, but yeah, I just I don't think it was ever envisioned that you'd have companies operating like this to courts and are saying like, oh well, the government strong arms you into doing it. It's like these guys were
No, I mean,
volunteering to
I
knock it
mean,
on the
in
door.
that respect, it's not. In that respect,
Yeah,
it's not new. You can find examples of this with private companies going back as far as you like.
yeah, but this is, I mean,
It's different in scale.
yeah, the scale of it, I guess, is yeah. So, Sweet Tooth Fairy saying, do you think if she had a better filing, she would have been more successful? I mean, there's only so many things you can argue, and yeah, if she had a better filing, sure, if they would have hit those points the court's saying, maybe, but there's a couple of times where the court said it was more appropriate under this part of the statute, but he
She
doesn't
she
go on.
got she got past the motion to dismiss. She's doing
Yes,
pretty well so
yeah,
far.
she survived. She survived. That's all that matters right now.
Her
But there's a
complaint is
couple.
really good.
Yeah, there's a couple of spots where the court said like instead of A1, it's A5. You should have filed under. That doesn't mean you would have survived under A5. The court's just saying you filed under the wrong spot. He could have
Yeah.
still said, "Sorry, this doesn't count." So that doesn't necessarily change anything. K Cash is saying, "What's that cool green light in the back for you, Kurt?"
Am I?
Yeah.
Yeah. So I just use LED strip lighting to create different color effects. So
Mhm.
I have LED lighting above, and then I have an LED lighting below my counter, my kitchen counter, and then I have LED lighting below my kitchen cabinets. And so then I set them to the color triad, so that the colors are all opposed from each other. So I think, because I like the color triad, because I think it looks interesting, because they're all the colors are as far away from each other as they can all be at the same time. So you got red, blue, and green. And then of course on a 12-point color wheel, you can have 12 different relationships. So I have a button that I can press, and if I press the button, it changes the colors to a different color triad.
Oh, nice. Nice.
So now
Very
you've got
nice.
a light green with orange and purple color triad. Push the button.
Was wasn't I
Yeah.
go with Clemson though too, the orange and purple?
Well, there's a reason that's orange and purple,
Yeah.
right? Because they're opposite color.
Yes.
But yeah, that's what it is. It's just some LED strip lighting and LED overhead lighting to create a three-tone relationship.
Yeah.
And then
Um,
it's really nice also, incidentally, when I do my batch record stories,
mhm.
because when I record a whole bunch of stories one after another, so then I just press the button every time I do a different story, and it creates
Mm,
a different color relationship. So it's another way to make the thing more visually distinct, as a way to try to improve and bring quality to the channel.
yes. Nothing but top-notch, production values here. Same with me. Rob Dorr saying there was a controversy of fact they had to go to discovery release. Exactly. Once you say "nuh-uh," there's now a controversy of fact. So keep that in mind, guys. But you should be using an attorney. But if you're ever trying to do this on your own and you're trying to say that you want to dismiss something by saying "nuh-uh," everything he says is wrong is not how you get things dismissed.
Mhm.
A-Dub says, "Can you wear assless chaps as well?" I'm assuming that's for you in court. I mean, chaps don't have an ass to them anyway. Otherwise, they'd be pants.
I
Uh,
don't know. I'm gonna go with
yeah,
no. I'm gonna go with no. But it is Austin, so who knows?
yeah. That too. Duncan 8 says spur the witness. Oh. Patty Letter saying, and the CIA killed President Kennedy, it turns out. Well, I mean, I don't think anybody really thought that wasn't the case. Where is... Rob Dorr saying, yeah, she threw everything at the wall. She did. They threw everything they could at the wall, and that was the best they could do. And certainly, guys, the attorneys she hired are going to be very good. That was the amount of people working on this, working all the time on this. It wasn't just like, oh, we're going to work on it for 5 hours. People were working all night on this. There were interns tearing apart LexisNexis, finding stuff. So I guarantee. Rob Dorr
tearing apart LexisNexis. That's a nice visual imagery.
Yeah. Well, I mean, are you a Westlaw guy, Kurt?
I don't really care between the two. I like them both.
Rob says, yeah, there was nothing left. Yeah, that was a very good effort they made, and once again, they survived. You know, that's why you shoot all those arrows. You hope you get a hit or two. So let's see here. They'll stab you or not.
Some people don't like the lights. I like the lights. I
Let's just
like I like the lights. I like the lights. I like the color triad. I think it looks cool.
No, I think it works.
It makes me happy. It brings me pleasure.
Hey, it works. It works. I have no problem with it. Unless I have to use tracer rounds. Okay, thanks. Justin Hancock says all chaps are assless. Yep, exactly what I thought. Chapless pants. Allegiant News says for $1.99. Thank you, by the way. Says dismissed case with sanctions was 22 or CV 22-677 PHX JJT. Okay. Alpha Fox says Westlaw fight me. You Lexus loving commies. Westlaw's awful. Westlaw's great for like law review. Lexus, I also use Lexus when I worked for I did work for oil companies, so you actually had to use the people finding part of Lexus. And I'll tell you this much, that's like being God when you can type in somebody's name and you can find everything out about them. It's really cool. I don't know if you've ever had the chance, but it's really neat.
I'm not.
Charles Watt says the establishment is still afraid of signature matches unless it's a recall petition. No lies detected there. Yes. Yes, they make sure those are 100% accurate. Very true. Or a candidacy petition in general. So, unsubbed by. Well, that's okay. I'll still see you at breakfast when I'm over to see your mom.
Yeah.
We'll split the cookie crisp. I promise.
Can't get enough of that cookie crisp.
Yes. I'll even let Fox. Alpha. I'll let you keep the toy too.
Nice. Which one?
Yeah. Arash saying, "What about the World Cup final?" I mean, I just wanted America to get to the finals and win because how funny would that be for a country that doesn't care about soccer wins it?
I'm convinced that the U.S. ever wins the Men's World Cup is truly the end of all world peace.
Yeah.
And we'll be the best at everything.
Yes.
Take away the last hope from the world. Lol.
Yes. No, I know that would take away everything they've got. Well, I'll be following the householder trial. Ion Energy's asking. I don't know do you know what that one is? I haven't heard it.
OnlyFans trial on Courtney Clenny is one I'm looking at. Murdaugh, which I think is still happening in January. So I'm going to be covering that gavel to gavel for sure.
Yeah. I know I've got the suitcase murder, Sarah Boone. That's set for the end of January.
Suitcase murder.
I swear to God, Sarah Boone and your attorney, do not continue it. I had to clear out my schedule for a whole week to make time for that. So don't fuck me over in Minecraft.
They keep moving trials. They just keep moving them.
Yeah, well, she had an issue. She got a new attorney. Truck Golfer says the World Cup is over. I know Argentina won. I
No, it was
guess.
a great game.
Yeah,
Great game.
I mean, it's.
Fantastic game.
I guess I'm happy that they're from America. Maybe not just the South Side, but it's still America. So America still kind of won the World Cup. I guess you can argue. Oh, Ion Energy. Oh, Householder. Yes. Oh my God, I forgot about this. So Householder was the Ohio Speaker of the House, and he got caught with a massive bribery scheme regarding some of the nuclear energy companies in the area.
Nice.
Holy cow. Yeah, he took. Oh, he got involved in it was like an FBI sting and like $1 billion bribery scandal.
Ooh.
There was a lot of money floating around. I don't know, Ion Energy. If that is televised, that would be interesting to cover. I don't know if it will. We'll see. I mean, if it's in state court, sure. If it's a federal court, we'll definitely never get a chance. So Patty Leather says soccer is only popular in countries bombed by the American military. We didn't
Okay.
bomb Argentina. Yes, Patty, I know you love the papacy, so he's very happy that Argentina's Catholic. Oh, it's 60 million. I'm sorry. Starts January 23rd. I might have trial January 23rd, so I might not be available for that one. Once again, I had to schedule everything around Sarah Boone, so that kind of screwed me. Rob Dorr gifted 5 memberships. Thank you, Rob. I appreciate it. And I know whoever got it is very thankful. Suitcase girl just had her lawyer quit again. Oh, fuck me.
I didn't like the 7th or 8th one.
She's been through a lot.
Well, it doesn't help that you videotaped the whole thing and laughed at it.
Well, but that if she didn't put him in there though, you have no duty to assist.
She did put him in there.
Maybe.
She zipped him in there.
I mean,
Don't
it's
think
not.
no?
It's not 100%. No, he was like a very small guy. It was kind of like a contortionist thing. So it's not clear. Now there is some sketchy stuff like when she woke up in the morning, she found him in there. She pulled him out, tried to resuscitate him, and then she shoved him back in and called the police. So like that's a little weird. But Sarah Boone's not exactly the brightest person in the world either.
Do you think he zipped himself into the suitcase?
Well, think about it. You can, and if you're think about it. Like with the zipper, you can kind of get it going. Well, you have to prove that he did that she did it. If she didn't do it,
Okay.
yeah. Josh is saying she flipped it over. Yeah, she might have. I don't know. I mean, that is an issue too. That on
She
video
flipped
it's
it
flipped
over
over.
and prevent his escape. That does it.
Well, it looks flipped over on video, but was it upright when he got in? I don't. That's yeah.
Yeah.
There's some issues there, and also I got to figure out how to kind of do merch for that one because for the Daryl Brooks one I could do the coffee cup, but I'm gonna have to sell
Yeah.
like suitcase tags or something.
I still have to go through the Daryl book trial and excise like him saying things like grounds. And
Yes.
is that lawful law so I can put it on my soundboard?
Oh, by the way, Kurt, you missed Chili De Castro. He finally got into constitutional law after you left last on Saturday night.
No, he didn't.
Yes, he did. Yes, he did.
Uh,
So you
I
missed
was
it. You
waiting
could
for a
have.
long time.
Yeah, well, it was worth it. This guy was no Houdini. Yeah. If the case don't zip, you must have quit. Yeah. But yes, Kurt, you're all right. This is the one she did film where he's like, help me, help me. And she's like, sorry. Oh, Salty Balls is saying, sell body bags or a brand is just right for significant others. No, maybe that might work. Well, guys, you liar, Sean, it was not worth it. Oh, what did I say was worth it? So, well, guys, that is it for tonight. So we shall see what happens. I know Viva is going to be covering Kari Lake's thing. I'll be in my office doing work. I'll be watching along. I'm very curious to see how this goes. And like I said, hopefully at the very least, some of these officials get called out and are made, That's the best we can do is accountability at this point. Like I said, I don't think it's going to go anywhere. I don't think it's going to help her. But it's a start. It's a start. Oh, here you go, Kurt. That's a shame says for $4.99. I started a compilation of Brooks saying grounds. It was like 15 minutes long, a third of the way through the trial. I gave up. Oh.
Just need it once for the soundboard, so I can just push it.
Yes.
from time to
Oh,
time.
Launder
Yeah.
clipped the part of you asking where to Kirk. Oh, I did. Oh, that's funny. Oh, there was a part. So there was a part where I called out for you because he started talking about. Oh, where is it? I didn't know they clipped it, but this might be funny.
Okay.
Oh, Kurt missed
Let's use a laugh.
Oh, yeah. Here. Oh, yes. He this might give you an aneurysm, Kurt. I warn you in advance. The part he touches on. All right, here you go.
You go to the First Amendment, right? And so you're going to get in the First Amendment, remember, it's going to be wraps. It's going to be religion, assembly, petition, press, and speech. You have these first 5 big liberties. So when it becoming
SBF can testify about suitcases. Jesus. Oh.
Infringed in the 1919 case of Cynic versus the United States, SCHKNECK, Cynic. It's a very funny spelling of the name, but in Cynic versus the United States, maybe you guys will remember the holding where I believe it was.
Is Chili talking about Shank v. US? I think he is.
Oh my God!
Wendell Holmes is going to write the holding, and he's going to write in there that your speech is limited.
Yes. Okay. Oh my God in heaven, Kurt, my brother. Why did you, brother? Why did you leave me, brother? Why did you leave me? You missed it.
Like Cynic.
Oh my God!
Talking about Cynic.
Oh my God!
Shank? What?
Oh my God! Oh my God! Oh my God! Muggard. Muggard. It's not Cynic for the United States. It's Shank for the United States. SCHENECK for the United States. It was in 1919. And Oliver Holmes did write the holding. And that's where we talk about the clear and present danger test. And that you can't shut fire in a crowded theater.
Yeah.
Yes. Yeah. And Shank was an abomination of a Supreme Court case. Why? Shank was a socialist protesting U.S. involvement in World War I. That's all he did. He was out on a street corner protesting it. That's all he did.
Passing a flyer.
And he got charged with Sedition Act violation. Very interesting how that, back 100 years ago, that would get you in trouble. But holy fuck. Yes. Holy shit, this illiterate fuck. Yes. Brent saying, close enough. No.
Cynic.
Rich G says Brandenburg v. Ohio blocks your path.
No, it's not called Brandenburg. It's called.
Yes. B-Man says socialists should have rights.
Wrong.
Okay, sure. But they use that same ruling against us. So.
Yeah.
Yes.
Rod didn't.
Yes. Oh my God, Chili. It's not Shank. It's Shank, not Cynic. It's also not Can't. I'm trying to be nice right now.
Can't scream fire in a busy movie theater. And so your First Amendment of free speech is limited by Oliver Wendell Holmes in the 1919 case of
That
Sinek
case has
versus
been
United States.
repudiated.
Well, was the Sinek case about him screaming fire in a busy movie theater? No, it wasn't.
That case
It was
has been abrogated.
about Charles Sinek and his
Yes.
wife, Elizabeth Bayer, who were handing out pamphlets to men standing in line for the draft for World War I, which is going to be fought from 1914 to 1919. And so
1918.
Sinek versus United States is going to happen in 1917 or 1918. And then the holding is going to come down in 1919, where Oliver Wendell Holmes is going to write in the holding that your First Amendment right is limited. You can't scream fire in a busy movie theater. But it had absolutely nothing to do with screaming fire in a busy movie theater.
Falsely.
And then they partnered with the big
Falsely.
newspaper industry, and that's going to be
Falsely.
and then they partnered with the big newspaper industry.
Yes, Chili. It's called dicta. The court is explaining things. It's called dicta. Fuck. That was the part I love. He's like, but it wasn't about shouting fire. So why did they talk about it? Yeah, brilliant move, Mr. Scholar.
Reasoning by analogy.
Yes. It's how you explain things. And he doesn't. Yes. Yeah, you can't falsely shout fire. And also, I do like a job well done says, but can you open fire at a theater? No, there's a Christopher Hitchens. He was giving a speech once, and somebody said something about it. He's like, well, I could shout fire right now. Fire, fire, fire. He's like, see, nothing happened.
I remember that one.
Okay, that's
I miss
hilarious.
Christopher Hitchens.
The late Christopher Hitchens. Very funny guy.
Yeah.
Okay, if you're considering, well, if you want to consider all the stuff that spilled over, like the Soviet-Polish War started in 1919, the U.S. is running around up in the Russian Civil War doing the American expedition, along with the other multinational forces operating out of Murmansk, fighting the communists. Okay, yeah, that was going on until 1919, but I don't think Chile knows that or is willing to articulate that argument. There was also the Greek-Bulgarian War. The Balkans were full of little conflicts in 1919 as well, but I don't think Chile's mentioning that. Yeah, there we go. It was just awful.
I'm dumber for having heard it.
Yes, I wanted to let you know, Kurt. I hadn't forgotten
Cynic.
about you. Yes, cynic. Man is awful, and he likes to check. He'll chalk that up to, well, I'm dyslexic.
Okay.
Yes. So
I think I have a very mild dyslexia myself that's undiagnosed because sometimes I read words a lot wrong and stuff. But yeah, no.
So
It's not an excuse for being a complete idiot.
yeah. So, what's that? Salty Ball says Chili hands out brochures for butt plugs. Yeah, he does. He probably models them too. So, well, guys, that is it for tonight. Like I said, we shall see what happens tomorrow for Kari Lake. She'll get to present, and then the next day, Katie Hobbs and the Gubernatorial will have their shot, and then the judge will release a decision. I'm sure it's going to be in the government's favor, but I think this is a start. The fact that finally a judge said, let's actually look at it. Maybe in the future,
she's got to bring it. She's got to really bring it. She can't be speculative and possibilities and innuendo. She's got to have actual evidence.
Oh, God, I hope she brings the tea. I hope she brings the tea. Which, if you need more tea, go to the Dragon's Treasure. Code word, promo code criminal. Do you have a promo code, Kurt, for them?
No.
Oh.
He asked, but I declined.
Oh.
But I do recommend the teas.
Be Catholic. That's never a bad answer. Pro or anti Operation Paperclip stream? Yeah, we could do one about that. That'd be fun at some point. Rob is saying, I think she's going to have a bunch of allegations with no proof. I think she's going to have some proof, but it's not going to be enough to get her over the top. So we shall see. Who knows? Maybe she's got something up her sleeve. Here's to hoping she throws down something interesting. So, Kurt, thank you so much for being on. I'm glad we actually got to talk about something interesting and constitutionally minded tonight.
Yeah, I learned about a whole new case, Cynic.
Yes.
Good.
Yes.
Great.
Yeah. Well, Rob is saying she only had 3 people in the complaint. Yes, 17,000 short. We'll see. We'll see. Maybe there's, like I said, maybe she knows something we don't know. I'm not gonna.
If the 3 are really strong as an
Yeah.
exemplar, then maybe. But I mean, she's got to have something.
Yeah, that's why.
You're
So.
asking for a lot.
Yeah.
Let's just be fair.
Yes.
You're asking for a lot. You're asking for a court to do a big thing.
Yes, well, at the very least, if not make you the winner, redo an election.
Which is also a big thing.
That's just as big. Yeah. And it's not like,
But if you came into my court, I'm going to be like, there better be real strong fucking tea.
Yes.
Like I got rumors of tea. I'm like, get the fuck out of my courtroom.
Yes.
You know?
Yes, that hypothetical tea. All right. Well, yes. Once again, Kurt, thank you very much. I appreciate it. I always love having you on. Always appreciate your insights. And guys, thank you for everybody here tonight. Everybody who's posted, liked, subscribed. Thank you so much. If you guys are on Facebook, hello. If you're on Twitter, hello. Daddy Elon is apparently not surrendering power yet, even though apparently.
Are you streaming to Twitter?
Yes. Yeah. StreamYard has it set up for Twitter, just because Rumble's such a pain in the ass right now.
That's cool.
But yeah, and also you got to pay also StreamYard wants the big time bucks if you want to start streaming to 8 different things at once. So
I signed up for this competing app called Melon, which is run by Streamlabs. Mm-hmm. It has multi-streaming and it's a little bit cheaper.
I'll have to talk to you about that because I might want to do that.
I don't know if it's the answer to all your problems, but I'm giving it a go.
I'll give it a shot. And then, guys, yeah, if you everybody is a member, thank you. All the memberships, thank you. All the super chats, thank you. And if you guys like Kari Lake, fingers crossed. And if you don't, let's at least see what accountability in election looks like. Hopefully, if you hope she loses, hope it turns out that everything's on the up and up. So everybody's got something they're rooting for. So good night, everybody.
Night.